Consumer Counterpoint. I'm Christine Argentine, one of your hosts at Sci-Fi Shaw.
And I'm Paul Ivanek, also a partner in the Chicago office of Sci-Fi Shaw.
And we are today doing a quick take because we wanted to give a quick update on the California SB 690 bill that relates to the California Invasion of Privacy Act.
Right, and obviously the California Invasion of Privacy Act has been a statute that the plaintiffs' bar has been going after for several years now. A lot of it in the early part, there wasn't a lot of interpretation on how the statute was applicable to what we're seeing now, which is website tracking.
Right. Well, mostly because it's a 1967 statute when such technology did not exist.
Exactly. So we see courts, over the last, couple of years weighing in, interpreting it, really being in some cases, as we saw recently, critical of the statute, which is, I think, what we're kind of leaning into now, which is this proposed amendment.
Right. And if you remember, this amendment, well, not this one, but an amendment was on the table last year and got passed, got kicked, not passed, from the legislature last year. And the amendment that was on the table last year was to put in a new exception under the statute, a commercial business exception, which was meant to address the wiretappings, right? Because all of these cases relate to pixels and technology that's used primarily for marketing purposes and analytics purposes.
Right. So kind of, I think the attempt was to try and really eliminate a lot of those lawsuits where, we're dealing with websites and consumers going to these websites.
Right.
So
that amendment is off the table. So what happened last week is on July 1st, the California Assembly's Committee on Privacy and Consumer Protection met and had a hearing where both sides presented, the consumer protection sides, the plaintiff sides, as well as businesses and the defense sides who have been continuously being hit with these cases and having to pay out.
So almost like an open forum.
That's right.
State your views and your concerns about, as it was being proposed at that time, how does that impact both sides?
That's right. And businesses were encouraged, and many did, submitted letters about the impact that this has had on their business, about the uncertainty this has created with their marketing teams, their IT teams, about how they could possibly comply with the law. And there was a real focus on, companies that are CCPA compliant, right, which is another California statute that really actually governs cookies on websites and what you need to do to make sure people can opt out, and how this has businesses that comply with that but still then are subject to these massive violations, massive lawsuits under this wiretap statute.
Yeah, so we don't have this broad business exception that we saw last year. What does it look like following the July 1st,
So the amendment that is being proposed, that is coming out of this hearing, is to remove the private right of action on the trap and trace claims.
Okay.
So Section 631 are the kind of those traditional wiretap claims that we've been seeing for the last couple of years, where they're essentially alleging that using this technology is allowing third parties to listen in on someone's communication with your website, and albeit a wiretap. Right? There's been another wave of cases, and at this hearing, they said there's been 4,000 of these cases filed in the last year.
Wow.
Under a different section of SIPA, which is 638.51, and it's the trap and trace. And that one doesn't require the same type of content, the same type of communication to be captured.
Right.
It's more about routing information. So think IP addresses, right?
Okay.
When one website communicates with another, or someone visits a website, their IP address is automatically transferred.
So almost like far more technical rather than content driven. It's more just that technical, the IP address and what's being transferred that way. Yeah.
And the trap and trace language talks in terms of addressing information. And so courts really struggled with how broad that language is written. And we're really split, right? A lot of courts saying the language is written broad enough that this could encompass the trap and trace language, this could fit. And other courts were saying, no, this is how the internet works. If you make this illegal, it's all illegal.
Right.
without consent.
Right.
So what came out of that hearing is essentially removing the private right of action for 638.51, the trap and trace claims. And the proposed amendment would be retroactive 2 years. Meaning that any cases, so assuming this makes it through and goes into effect January 2027, any cases filed January 1, 2025 on would not have a claim anymore.
Wow. Okay. And so I'm just trying to think, how, I mean, we've seen this in other statutes where they change the law, there's no express retroactivity, but is there potentially constitutional challenges of retroactivity? Because I'm trying to figure out how did they come up with, a proposal of 2-year look back instead of 5-year or
Right.
whatever it might be.
Well, the statute of limitations on SIPA is only 1 year.
Right. That's what I'm
Right.
trying to understand. Where do we get to 2 years
So
then?
the 2 years was really primarily focused on trying to moot the massive amount of cases that have been filed.
I see. Yeah.
Right? And so I don't know that there's necessarily a constitutional issue with the retroactivity, because the constitutional issue generally comes more from did you know that you were violating, like, were you doing something that you should have known that now suddenly has become illegal, right?
Right.
This is kind of the opposite of that.
Yeah.
Something you were already doing now is becoming, that is being accused of being illegal, is becoming not
Right.
illegal, but there's no private right of action for it
yeah.
anymore. So it's not to say that businesses shouldn't be mindful of obtaining consent, because even though there's no private right of action,
Consumers still have those rights protected. It's just not through a private right of action.
correct. The California,
Sure.
The
The AG's office.
AG's office
Sure.
has to enforce that.
Sure.
So it's good news, right? Mostly
Absolutely.
because there's a certain pro se out there who has been sending thousands of letters out, and his letters are all based on the trap and trace recently.
Yep.
Originally, he was under 631, that traditional wiretap claim, and now his claims have been under 638.51. That would moot all of these demand letters that we've been seeing, and he's certainly not the only one.
No.
Many plaintiffs' firms have been pursuing trap and trace claims as well. So it's good news for businesses, assuming it gets passed. Right? We still have some work to do.
So the bill was introduced last week.
So the amendment was kind of put in place, like decided on by both sides, and passed the committee last week.
Right.
committee-
Following the forum that they allowed people to speak at.
Correct.
Right. Okay.
The committee is supposedly still considering possible other changes to this amendment. The California legislature is on summer break right now.
Yep.
So they come back in August and will take up this 690 bill with this proposed amendment that seems to be supported on both sides.
Okay.
Right? So people are optimistic that this is going to make it through, but it of course needs to still be finalized by the committee, be passed by the Senate, be passed by the Assembly, and then signed by the governor.
Right.
And that has to happen in August,
Okay.
or it doesn't go
It
into
gets-
effect, right? It gets kicked again, just
Right.
like it did last year.
Right.
So we certainly will keep an eye on it. We certainly will see what happens. I think everyone is a little bit optimistic right now
Sure.
that this is the narrow piece that could make it through. Now, it doesn't do anything to the 631 claims.
Right.
Right? Which, of course, are out there. Many businesses are litigating. Many businesses are still receiving demand letters over. There's nothing that this amendment touches that relates to 631A.
Right. And so that's all to say that while this amendment is great for businesses, compliance under California law, under SIPA, is still very important.
Right. It doesn't change the idea that you still should be seeking, making that transparent disclosure to your consumers that you use this type of technology on your website,
Right.
and seeking the consent from those consumers to use that technology, and making their ability to opt out of that sharing of data very, very easy. We
And
still need to
before
do all of
anything
that.
is captured or transferred.
Before, anything that your website loads, none of that fires until that consent, or at least that transparent notice
Right.
is given.
Right.
Right? Because remember, consent could be implied, doesn't necessarily have to be a click of a button, but that's still up for debate in
Absolutely.
the case law.
Awesome.
So we will keep you all posted on what happens with that bill.